5, 4, 3, 2, 1, start. This is a petition filed by the petitioner under Section 11 of the Arbitration and Conciliation Act 1996 for appointment of an arbitrator. Full stop. The case of the applicant is that it is a company incorporated under the Companies Act 1956 having its office at 140 Pranami House, August, Rohini Marg, Mumbai. Full stop. The petition was filed through one of the authorized representative of the company. Full stop. It was alleged that the respondent number 1 is also a company and misleading the members of the consortium along with the respondent numbers 2 to 4. Full stop. The respondent numbers 1 to 4 are the members of consortium which bid for development of city center project for Barnala. Full stop. It is alleged that respondent number 5 is also a statutory authority and is called the Barnala Improvement Trust, vested with the responsibility of development of city of Barnala. Full stop. It is alleged that respondent number 5 had invited tenders from eligible entities for implementing the construction of the city center project at Barnala. Full stop. Pursuant to the said invitation, the respondent numbers 1 to 4 were one of the successful bidders for the said construction and had signed the memorandum of understanding with the respondent number 5 on 4/5/2004. Full stop. It is alleged that the respondent number 5 had put respondent number 1, a member of the consortium, in physical possession of the plot according to the agreement executed on 14/5/2004 along with the power of attorney dated 28/2004 executed by respondent number 5 in favor of respondent number 1. Full stop. It is alleged that by an agreement dated 11/1/2005 the applicant purchased a property measuring 1,55,000 square feet area on the lower ground floor of the building proposed to be constructed by the respondent numbers 1 to 4 at the said city center for rupees 50.84 crores at the rate rupees 3,456 per square feet along with the undivided proportionate share in the land. Full stop. Stanza. The said agreement was that the respondent number 1 for the and on behalf of respondent numbers 1 to 4 as well as respondent number 5 in the capacity of an attorney had signed an agreement of sale of certain built up area proposed to be constructed in Ludhiana. Full stop. The agreement recorded total sale consideration of rupees 50 crore 84 lakh, out of which a sum of rupees 14 crore 50 lakh 20,000 was paid by the applicant by way of two demand drafts bearing numbers 1466 dated 17/10/2004 and dated 7/1/2005 in favor of the respondent numbers 1 to 4. Full stop. It is alleged that clause 60 of the said agreement contained an arbitration clause that in the event of any dispute relating to the said agreement arising between the parties, the same would be referred to a sole arbitrator in accordance with the Arbitration and Conciliation Act 1996 with the seat of arbitration at Delhi. Full stop. It is alleged that the respondent numbers 1 to 4 could not develop the said city center on account of the dispute having arisen between the respondent number 5 on the one hand and respondent numbers 1 to 4 on the other, as there was a change of government in the state of Punjab. Full stop. The applicant had accordingly prayed for appointment of an arbitrator to the respondent numbers 1 to 4, and since the respondents had failed to appoint an arbitrator, consequently the present petition has been filed. Full stop. The respondent numbers 1 to 4 filed their response to the petition and contested the claim of the applicant on various grounds initially. Full stop. Stanza. The respondent number 5 also filed the response to the application petition for appointment of an arbitrator full stop. I have heard the learned counsel for the parties and perused the record full stop. So far as the objections of the respondent numbers 1 to 4 are concerned, they are in fact not considered on merit on account of the fact that during the course of arguments the respondent numbers 1 to 4 have very fairly conceded that they have no objection for appointment of an arbitrator for adjudication of the dispute purported to be raised by the applicant with the respondents full stop. Both the learned counsel for the applicant and respondent numbers 1 to 4 had agreed to act as the sole arbitrator for the purpose of adjudication of the dispute arisen between the parties full stop. So far as the respondent number 5 is concerned, it did not appear at the time when the matter was considered by the learned counsel for respondent numbers 1 to 4 full stop. Therefore, the court did not have the advantage of hearing arguments on the basis of objections which are purported to be raised by respondent number 5 to the application of the applicant for appointment of an arbitrator full stop. However, their response can be constructed from the reply which is filed by them to the application under section 11 of the Arbitration and Conciliation Act full stop stanza. A perusal of the said reply by respondent number 5 shows that the main objection which has been raised by the respondent number 5 to the appointment of an arbitrator is that the agreement dated 20/5/2004 which is purported to have been executed between the respondent numbers 1 to 4 and on behalf of the respondent number 5 in the capacity of an attorney could not be a ground for entitling the applicant to appoint an arbitrator in terms of the said agreement full stop. It is alleged that the entire agreement dated 20/5/2004 was based on fraud, forgery and cheating, as a consequence of which, after vigilance inquiry against the officials of Barnala Improvement Trust by the IGP, a case bearing FIR number 10/2006 was registered on 20/5/2006 under sections 420, 467, 471 and 120B IPC and sections 13 (1) read with section 13 (2) 14 of the Prevention of Corruption Act 1988 in Police Station Vigilance Bureau Mohali full stop. It is alleged that a charge sheet has since been filed and therefore as the agreement itself between the respondent number 5 and respondent numbers 1 to 4 is based on fraud and forgery, therefore it should not be made as a basis of appointment of an arbitrator for adjudication of the so-called dispute between the applicant petitioner and the respondent numbers 1 to 4 full stop. It was also alleged that on the basis of the same reasoning, the respondent numbers 1 to 4 could not be treated to be as attorneys of the respondent number 5 full stop. Next, it has been urged that before filing the present petition under section 11 of the Arbitration and Conciliation Act 1996, two attempts were already made by the applicant before Punjab and Haryana High Court by filing applications under section 11 of the Arbitration and Conciliation Act full stop. The first case was registered as an arbitration case bearing number 163/2005 which was dismissed on 20/8/2006 full stop. Another petition came to be registered as arbitration case number 60/2006 wide order dated 9/11/2006 full stop. It has been thus averred that after the receipt of the said order, the respondent numbers 1 to 4 have now chosen to get the dispute adjudicated between the respondent numbers 1 to 4 and the respondent number 5 with the help of the applicant/petitioner by filing the present application as a surrogate petition full stop. I have carefully considered the plea of the respondent number 5 as given in their reply full stop. The sum and substance of the challenge of the respondent number 5 is essentially challenging the jurisdiction of the arbitrator to adjudicate the dispute as well as the very factum of appointment of an arbitrator in terms of the arbitration clause between the parties on the ground of the agreement being vitiated by fraud, forgery, etc. Full stop.